Good morning, everyone. Thank you very much for inviting me and for having me. And I very much hope that our visit to the concert hall last night got us in the right mood to hear a bit more about theater and live arts performers. So let's take a look. My plan for the next 30 minutes is to first go a bit into the definitions, to look what is kind of the scope we're talking about today, what are the live arts and what are the creators that we're going to discuss today. Then we will dive into the legal framework. Of course, I'm from WIPO, so we will take a look at the international copyright treaties. And then, as a third point, I would like to take the example of stage directors to kind of walk you through and to explain a bit more what the different approaches are as regards the protection of stage directors. When we started the discussion about live arts at WIPO, we actually started off with the stage directors, which is also why I chose the stage directors as an example for today, because there is already some work that we have done on that. However, while doing that, we realized that many of the questions that arose are actually not only concerning the stage directors, but also many others who work in, on, and around live arts performances. So we broadened the scope, and in the discussion that we're having right now, we're taking a very broad definition. So live performances can be anything from theater, opera, dance, street performances, and so on. So we're not really excluding anyone for now, so to have the discussion with everyone who might be affected here or not. For the creators in the live arts, I kind of grouped them to kind of give us a bit of an easier approach. On the very left, we have those who are kind of creating the underlying work. So those works that are to be performed in live performances. That can be a musical work, a dramatic work, etc. So we have the writers, the librettists, composers, choreographers, etc. Then in the second group, we have those that work a bit as the intermediary to bring these works to their audiences. So these are the people that are on stage, that the audience actually sees when they go to a theater or to other music performances. And they are the actors, singers, musicians, and so on. And then in a third group, we have those that are not necessarily seen by the audience. Maybe the conductor, he's still there, the audience can see the conductor, but many others who also provide some more or less large input for stage and live performances are actually working behind the scenes. And what they do is sometimes not really visible for the audience, but still they provide some input, some of them also some creative input, to make a live performance possible and to bring it on stage. As regards copyright and related rights protection, the situation for the first two groups is pretty easy to answer. So the writers, librettists, etc., this first group, they create the works, so they are considered authors, and they are protected. The second group are those that perform on stage, that interpret works, so they are protected under performing rights. They have protection under neighboring or related rights, as we call them. And then we have this third group, which is not that easy to grasp and which raises a few more questions, because how much is their creative input? What are they actually doing? Are they working creatively or not? So this third group is actually the group that we're going to look at, that we're going to look at today, and to find out what is their level of creativity that they provide to a live performance production. Do they deserve protection? And if so, under what regime? Are they authors? Are they creating something? Or are they performers, maybe? In this context, you also often hear one point where people say, well, this third group, maybe not the conductors, but many of the others working behind the scenes, they're actually not really creators, they're technicians. So we have light technicians, we have stage technicians who set up the stage and prepare everything for the performances. However, this argument to me is not really convincing, because if you look in practice, and if we take, for example, a lighting designer, there's a difference between a lighting designer and a light technician. So the lighting designer is the one who creates a light concept for example, a theater performance. So you use the light to create a certain atmosphere in the room, on the stage, or in the audience. You use maybe lighting effects to support whatever is going on stage. So you can really use the lighting as an element to support the performance and to use it also in a creative way. So the light designer, in my opinion, definitely does some sort of creative work. However, the light designer is not necessarily the one who puts in place this lighting concept. So there you come, you have the lighting technicians who then kind of set it up, put up the lights and the spots, etc. So they are the ones doing more of the technical work, and so far I do agree, yes, these technicians probably do not fall into the frame of copyright, but the light designers, those who really come up with the concepts, the same for the music or sound designers, etc. So for me, they do have some level of creative work and might also deserve some copyright or related rights protection. So the question one has to ask is, what are these professionals actually doing? So I will call them life arts creators, just to give it a name. So we're always talking about this third group of people behind the stage. And the question is, what are they actually doing? Are they creating something? Is it some work on their own? We just heard in the presentation before, you need some level of own creative input, you need to reach a level of originality, something of your own personal touch, as we just brilliantly heard. So what are they doing? Is what they do sufficient to qualify as a known work, so which would result in the protection under author's rights? Or are they rather performers? Are they interpreting a work? So what is the situation here? And I can already say at this point, without spoiling too much, these questions are answered very differently in different jurisdictions, and also with regard to different groups of professionals. So the arguments for or against protection for a conductor are different than the arguments for or against the protection of a set designer. So in order to get closer to a solution, let's look at the legal framework. And of course, I put the timeline of our international copyright treaties here. We have the Berne Convention, later updated by the WCT for the author rights protection, and then of course the Rome Convention, later updated with the WPPT, which is the WIPO Performance and Phonograms Treaty, and later the update by Beijing. So these are the main provisions or treaties and conventions we are going to look at. So starting with Berne, we've seen Article 2 of Berne today already, so I will keep it short. Article 2.1 gives kind of the definition of what is a work. And this is a very broad definition. It says it shall include every production in the literary, scientific, and artistic domain, whatever may be the mode or form of its expression. And after that, there follows a list of possible works. In that list of possible works, we do have some that are related to stage and theater. We do have dramatic or dramatico-musical works, choreographic works, etc., musical compositions, but these are all more kind of the underlying work that is performed on stage. So that does not really help us to find a solution for our life arts creators that we are discussing today. However, the Article 2 is defined very broadly, and its list of possible works is not an exhaustive list. It says such as, so possible other works can be considered, and it's up, of course, for the national legislators to include more works and other works if they wish to do so. So that would still open up the possibility to have in national laws more works than those that are enshrined in the Berne Convention. 2 points I want to mention in the context of this article, just to kind of, for sake of completeness, is the paragraph 2, which contains the fixation. This says that it's a matter for national legislators, if they want, to include the criteria of fixation in their national law. This was something that came up during one of the revisions of the Berne Convention in context of the discussion on choreographic works and entertainment in dump shows. Dump shows, by the way, is only another word for circus. And there was a discussion whether a fixation is actually required for these works. And there are jurisdictions that require fixation, mainly in common law countries. And in the end, paragraph 2 was included in order to open the door to those countries that have the fixation in their national law, to give them the possibility to join the Berne Convention and not to be kind of pushed away because they cannot apply their own legal traditions when joining Berne. Namely, back then it was the United States for which this was opened up. And then in third, paragraph 3, we have the adaptations. This is something I have not really seen in national jurisdictions, but it's something that is discussed in literature, where, for example, for a stage director, it is said, well, if you have a dramatic play, let's say, and they're also taking Shakespeare, let's say we have a Shakespeare play, is the bringing on stage of that Shakespeare play maybe an adaptation of that Shakespeare play, and with that, it becomes a work, and those who are creating the adaptation become an author? There's a lot of discussion, and again, this question is not finally solved. So authors' rights might be one way to protect these life arts creators. And I've been doing a little bit of research in the region to see what the national laws are saying. And I found some examples, for example, Lithuania, that have in their copyright law a definition of what is the subject matter of copyright. And among others, you find the theatrical productions there. In Estonia, I found productions of work and set design. And in Hungary, we have the costume and scenery designs. So if these are works in the national copyright law, that means that those who are creating these works are authors and enjoy protection. This is one approach. The other approach would be to say, well, actually, they're not really working or creating some works on their own, but maybe they're interpreting. So they're a bit more like a performer, like a musician on a stage who performs the music and interprets the music, giving some creative input in the musical performance. Maybe there are some of these creators that could be considered under related rights as a performer, as an interpreter. So here we have the Rome Convention that defines performers in Article 3, and it says performers are actors, singers, musicians, dancers, and other persons who act, sing, deliver, declaim, play in, or otherwise perform literary or artistic works. So this definition doesn't really help us. From the text, it's not really evident. However, if you look into the report of the diplomatic conference on the Rome Convention, it becomes clear that the drafters, when drafting this definition of performers, actually had one group in mind, and that was the conductor. So although the conductor is not explicitly mentioned in Article 3, it becomes clear from all these documents from the diplomatic conference that the drafters were actually thinking of the conductor, and although it's not mentioned, one can consider that the conductor is still a performer under the Rome Convention. This also got a bit more of a basis with the WPPT and the Beijing Treaty, who kind of took almost word for word the definition from the Rome Convention. However, there's one small addition, and that is the small word interpret. So that says performers are those who act, sing, deliver, declaim, play, and interpret, and otherwise perform literary and artistic works, and so on. So this interpretation of a work might not work for all stage professionals in the life arts working behind the stage, but definitely for a conductor. And in fact, the conductor is one of all those professionals that we're looking at today who has a kind of, well, recognized performer's right in many national laws because of this legal basis here. Again, for sake of completeness, I also want to mention the Article 9 of Rome Convention. So the Article 3 is for performers who perform literary and artistic works. The Article 9 is for artists who do not perform literary and artistic works. That means this is the group of people, for example, working in variety shows or circuses. So they don't have, like in a theater, you have this play of Shakespeare that is then brought on stage. So there's an underlying literary and artistic work. In variety shows and theater, or in variety shows and circuses, you do not necessarily have an underlying work that is performed, but still these artists are also protected as performers in the Rome Convention. So again, I did some research to see how is this done. Are there countries who actually do use the related rights in order to protect creators? The Latvian law uses a bit of a kind of conventional definition, pretty close to the Rome, but doesn't really open it up to to the group that we are looking at today. Different in Poland. Article 2 of the Copyright Act includes performances, shall include in particular the actions of actors, reciters, conductors. Here we have it written out in the law. The conductors are mentioned explicitly. Instrumentalists, singers, dancers, mimes, and then it gets interesting, other persons making a creative contribution to the creation of a performance. So here we have a rather broad definition, so it would be interesting to hear from our colleagues of Poland how far that actually goes. But it's a good example to see that in the law you open this up and you recognize that not only the people who are on stage and singing, dancing, etc., but maybe also others in the background can be considered as rights holders. So from this, I hope you understood that the situation is far from being clear, and there's little harmonization, also not in Europe. There are different approaches, different approaches for the same group of performers, or not performers, for the same group of creators. So some are protected under authors, some are under related rights, some have no real protection based on the law, so the question remains a bit unclear. But one more thing I wanted to show you is that there seems to be a trend to slowly open up also to these life arts creators, because there are more and more collective management organizations that also cover and then recognize these creators and represent them, so to make sure that the money from their works or performances actually flows back to the creators. I just did a bit of research here, probably or possibly there are more collective management organizations. Some are also more reluctant to open up than others, and also not all creators of this life arts creators already are represented, but there seems to be a trend that also on the level of collective management, these creators get more and more recognized. So let's look at the stage directors just as an example to look a bit closer of what are the arguments for or against protection, and if protection, under what regime, under author right or performers' rights. An interesting point in this context that I just briefly want to mention is kind of the comparison of stage directors and film directors. Because in EU law, you have several directives that refer to audiovisual works, and they usually say that, wait, I have the word here, that director of a cinematographic or audiovisual work shall be considered as its author. So for film directors, it's very easy, they are authors. So at least in Europe, might be different in other parts of the world, but for Europe context, it's pretty straightforward. So when comparing to a stage director, one might wonder, because film director, stage director, they're doing pretty similar work, conceptually even identical. They kind of are in the center of the creative process, but still, for stage directors, the situation is not as clear. This has different reasons. one is, of course, and here we're going back to the initial question, what is it that the stage directors are doing? Are they actually creating something? Is this something that is even reaching a level of originality, where there is enough personal touch in that work so that it is considered as a work under copyright? Or are they rather interpreters? Are they interpreters of a Shakespeare play when they're bringing it on stage? And the answer to these questions are very different in different jurisdictions. Another point that came up is the question of what exactly, if one says, okay, they are creating works, what is the work? Is like the production as such a work, no matter how often it is performed? Or is every night that I perform the production even creating a new work? So do I have a lot of similar works for the same production? Also a question that has no final answer yet. Then another point is that just as theater is a world with human beings working, it's a dynamic progress. So the production that you see on the premiere night might not be the same production that you see 3 months later. Maybe the cast has changed, maybe some scenes have been changed a little, or some scenes might have been cut. So is it still the same production, or does it evolve over the time? Also not quite clear. And then finally, it's a question of how much own input can a director even give. If you have, for example, repertoire productions, which run every year again and are set up every new season, of course there is a director who works with the actors, with the performers, to bring it on stage. But if it is a production that already existed in the past, how much own touch can a director actually give? How much creativity can the director put into this production? The case is different when we talk a production that is premiered for the first time. In that case, of course, the director has all the possibilities and can work with all the players involved to really create something new. And there, the leeway for the director is, of course, much larger. A lot of questions with, unfortunately, only little answers. So let's see how this is done in practice. We have different approaches. There are countries that provide protection under authors' rights. We have countries that provide protection under related rights, and then in the third case we have countries where the law is just silent. And then, of course, it's up for the courts to interpret the law and to come up with a solution and decide whether protection shall be granted or not. So for the first case, with national laws that provide protection for authors' rights in their law, I found an example in Portugal where the Copyright Act says that dramatic and dramatical musical works and their stagings are protected. So even the bringing on stage is a work. So the director who is working on that production then is or could be an author, depending on how much his input is. Similarly, in Lithuania, where I also found the theatrical productions mentioned explicitly in the law. For the second case, with related rights, there is an example from Croatia, where the Copyright Act explicitly mentions a director or of a theatrical performance and also a conductor of an artistic ensemble shall be deemed as performers. So here we even have the director explicitly mentioned, so apparently in Croatia he is considered more of a performer. And then finally, we have the situation where the law remains silent, and this is where it gets interesting, because it's now for the courts to say, what is a work? And is what the stage directors are doing, is that qualifying as a work? Are there authors, or are there maybe performers, are they interpreting? Some of that might even be a case-by-case decision, and you can't really globally answer that. There have been two streams. There are courts who are favorable for the provision of protection, and there are courts who are a bit more hesitant. For Europe, we had decisions in France who were always very much supportive for the theatre and for the arts. So in France, the court said yes, a stage directing is a work, and that is because of all the decisions that a stage director is actually making. The stage director has a big influence on the final outcome of the stage production. He can compose the scenes, he can select the sets and the props, he can direct the actors, so he can even influence on what the performers are actually doing. So he has so many creative choices that what he is doing is considered a work, and thus in France stage directors are considered authors. Similarly, a rather recent case in Italy from 2021. This was a case on an opera production at the big opera in Verona on an Aida staging. And there again, the Italian court said, yes, the staging of this opera is a work under copyright, and the director enjoys author's rights. A bit different, Germany, where we had one important decision a while ago. Here the court said no, at least in that case, it's not really a known work. The stage director is more considered to be a performer. It's more interpreting the underlying work. And thus in Germany, the court finally found that the stage directors are supposed to be a performer and protected under neighboring rights. However, interestingly, there is some discussion in Germany to say, yes, basically a performer. However, if the work and the input that the director provides or shows enough originality, enough creative input, enough personal touch, it could even qualify as a work, and then the director becomes an author. So it's a kind of a mixed system underlying the performer's rights, and provided the input is creative enough and you reach the level of originality, then it moves up to author's rights. This mixed system also exists, I think, in Hungary, and I also think in Sweden there's a discussion in this regard. Then we have courts who are less favorable. And as you can see, I listed some countries here. These are all countries from the common law system. And this also explains why we have an issue here, because as you remember back when we spoke about the Berne Convention, it says in paragraph 2 that national law can provide a fixation of the works. And there was, for example, an interesting case in the US. By the way, for the common law, I did not find any final decisions yet. There were some cases that were bringing up this topic. However, there was no final conclusion, no final decision on it so far. And for example, the case in the US, there was the question of whether a stage director can qualify for copyright, but in the end, the judge did not answer the question because he said the parties did not provide sufficient evidence for him to make a decision. But from the bit of remarks and comments that he gave, it became very clear that it seems rather unlikely in the common law, at least in the US, to have the director qualify as a copyright owner. The first problem that the judge saw was the originality, at least in that case. It might be different in other circumstances. And the second problem that the judge saw was the criterion of fixation. So the judge had issues understanding how a live performance that is living on stage can be fixated in a way that is sufficient under US law, or at least the parties were not able to show that to the judge. So there is a big question mark here, and since this fixation requirement exists in many common law jurisdictions, it seems at the moment rather unlikely that a protection could be possible. So with this, one can say that the situation is very diverse. There's only very little harmonization. And even as the example from stage director shows that it's even for the same group of creators, it's not very clear. Some say it's an author, some say it's a performer, and even in other parts of the world, they do not have a protection at all. One thing that we found at WIPO is because we now are reaching out to the professionals to get their opinions and to see what issues they are experiencing in their daily work. There seems to be a growing awareness among the creators. So they are aware that there is an issue, that they're not are considered as, or they're not having the same status as creators as other colleagues they're working it on the same productions. So there is a growing consciousness that maybe there are or there should be more rights to these groups of creators, but as you have seen, the situation remains very diverse and for many, unfortunately, also very unclear. So in case you're interested in the topic, I can recommend to take a look at this study that WIPO commissioned a couple of years ago. It was presented in 2021, and this is a scoping study. So it doesn't, fortunately, give no final answers, but it provides an outlook of different regions in the world and gives examples of national jurisdictions. I also took some examples from my presentation today from that study, and gives an idea of what the situation is like in different countries, in different regions, and also gives a bit more context of why the situation is like this. So feel free to take a look. And with that, I come to the end of my presentation. Thank you very much for your attention.